Hi, everyone, and welcome back to the Google My Business Problems series. Today, we are going to be talking to Erica D'Angelo from D'Angelo Law, and she is going to be talking about office action letters. So if you have already started your trademark process and you have gotten one of these letters, we're going to talk about what it is and what you need to do. Erica, what in the heck is an office action letter?
An office action letter is essentially a preliminary refusal of your trademark application. But don't panic because there are ways around it sometimes.
All right, so you need to tell us some of this and what we need to be watching for and that sort of thing.
All right, so you probably, you file for your trademark application, and then about 4 months later is when you hear back from the USPTO. If you received an office action, that means that something went wrong in the application process or in the search process by the trademark examiner. So you'll want to evaluate whether your problem is administrative in nature or is it substantive in nature. A few examples of an administrative problem would be a refusal because you didn't disclaim a piece of the mark that isn't registerable. For example, Joe's Coffee Shop, you would have to disclaim coffee shop because nobody can have ownership interest in a coffee shop that's called coffee shop. Another example would be if there was a foreign word and you didn't translate it in the application, they'll require you to go ahead and do that. So if one of those types of issues happen, it's generally easy to overcome that type of issue. Now you just have a little bit of a delay in the process. But if you received more of a substantive refusal, that's when it can be a little bit more tricky. So one of the most common reasons for an office action or an initial refusal is because of likelihood of confusion with another mark that's already registered or a mark that's been applied for that also could be very similar to yours. If you think about it though, anybody who has gotten a trademark on the register wants to be able to protect that from future marks that are similar or confusing to be registered. So it's the trademark examiner's job to weed through that and make sure there are no similar marks. So they often err on the side of caution in case there's a dispute in the future. So if your mark is similar to the other mark, it's time to do an evaluation. And this requires a legal analysis and an understanding of trademark law and cases that have kind of changed the way that the examiners are required to make this evaluation. So there's a landmark case, it's called the DuPont case, and there's a set of factors that the examiners are required to consider, and that is what an applicant will have to use when making their legal analysis and argument as to why their mark should be approved despite the potential confusion that the examiner suggested. Another very common substantive issue on office actions is refusal based on descriptiveness or geography. In this case, you may not be able to get your trademark, which is why it's so important to do this evaluation before you spend money on filing for the trademark. In those cases, you might not be able to overcome those types of refusals, but it's good to talk to somebody who has experience and find out what your options are.
Excellent. So for those of you out there that have gotten an office action letter or you're Googling this right now because you just got one, Erica is available and you can give her a call to help discern what it is that you did wrong or what research you didn't do before you actually filed. So my name is Brooke Borup with My Clone Solution, and this has been Google My Business Problems. And you can get Erica's information on the next slide. Have a great day.